Okay. And just for those of you who are just joining us, we're really excited to have David Ware back with us. He's been coming and presenting to Owen for a number of years. And so I'll turn it over to him. And thank you so much, David.
Thank you, Brooke. And it's an honor, of course, to be presenting again to Owen, but it's a dishonor or a sad thing not to be presenting at Owen. So next year I will be there in person with bells on, hopefully, unless some crazy COVID variant has wiped us all out. Greetings, everybody, and welcome to an immigration session that's going to deal with everything after graduation. I'm going to touch very briefly on permanent residence, but I'm really going to focus like a laser beam on H-1B visas and alternatives to H-1Bs, because that's what you need to know now. Permanent residence you can sort out, once you get into a job. Our firm, just for your own information, is based in Seattle, New Orleans, and Denver. So we stretch across the continent. And we've been in business for about 39 years. I have focused consistently all my immigration career on higher ed and folks coming out of higher ed, students, exchange visitors, professors, workers going into the private economy on OPT and CPT, those kinds of things. So we've paid a lot of attention over the years to students and their issues and their problems, and that's why I get invited to schools all over the U.S. to speak about post-graduation employment options for students. Regarding questions, please put those in the chat box. I will answer as many of those as time permits. If I don't get to answer all of them, Brooke will send them over to me after the session and I will answer them by email. If you have a question after the session is over, please shoot me an email. If the question is simple, I'll answer it back by email. If it's very difficult, I'll ask you to set up a consultation with me. And of course, like any reputable law firm, we do charge for our consultation fees, but they get credited back to your account if you later hire us for any work. So let's get started. Generally, we're going to talk in general terms today. This presentation is not legal advice regarding your situation. You should know, a lot of people don't realize this, in the world of immigration, very tiny differences of fact can make a huge difference in your immigration case. If you want to get my advice, particularly on your case, please make an appointment or shoot me an email, either way, or seek some other qualified attorney, immigration attorney of your choice. And be very careful in choosing an attorney. Immigration attorneys focus in lots of different areas. Many of them are not focused on employment-based immigration. If you have another type of matter you want to ask about, such as asylum or immigration through marriage, make sure you ask the attorney lots of questions before you hire them regarding their experience in the particular area of immigration that you're interested in. So very important that you not get advice from friends or relatives. Every day, I can't tell you how often I get emails saying, my friend told me to do this, or my uncle told me to do this, and it's completely screwed up the person's situation. So please, please, please don't do that. They're the worst source of information. Don't consult non-attorneys for your immigration advice. There are lots of folks floating around out there. You'll find on the internet, they'll pop up here and there. They're not attorneys, but they claim to be able to offer immigration services. Very dangerous to use such a person because they don't have a license. They have nothing to lose. They can take your money and they can disappear overnight. Attorneys can't do that. Attorneys have a license. They can lose if they take your money and don't do adequate services or don't do anything at all. Very important that if you have a question about your student status, that you first seek advice from your international office. They have years of experience and decades of professional training in students and their benefits. So they can answer your question best first off. If they refer you out to an attorney, then great. If you have a difficult question regarding your status, such as OPT or CPT or something like that, they may refer you out, but first go to them. And if anything I say today conflicts with advice that your international office has given you, please follow their advice. They've been in touch with you for several years now, probably, at least a year. and they know your situation much, much, much better than I would in just a few minutes. So the kind of general plan that you should craft for yourself if you want to stay in the U.S. after graduation is this: 5 easy steps. Okay. First of all, complete a degree in a field in demand in the United States. And as you know, there are a lot of different specialties in the MBA world and in the Masters of Finance world. So you want to focus on something that is in demand. Just to give you one example that I know about that's in demand is, of course, informatics or business analytics or supply chain management. All those things are in high demand in the U.S. So if you can focus in one of those areas, you're good. If you focus in another area, maybe so. But in order to figure out what is in demand, you need to go to career services. And do you guys have a separate branch for the business school, Brooke, or did they just go to the general career services office?
Everybody at Owen comes through our office, and then undergrads and others use the general office.
Great. People ask me all the time, how do I know if my field's in demand in the U.S.? Well, the only way you're going to figure it out is going to talk to Brooke or someone in his office about, demand for your particular specialty whenever you plan to graduate. Some fields are just not too hot right now. Other fields are super hot. So make sure you plan early that on your specialty so that you realize that by the time you get to graduation, your field will still be relatively hot. The equation is really simple. If you're in a specialty that's not in demand in the U.S., you won't get job offers. So you won't get as many job offers as you would if you get into a hot field. Definitely don't miss out on OPT. And I think you guys now have business analytics, right, Brooke? You do?
Yep. We have all of the Masters of Finance, and then for the MBAs, it's both operations, analytics, and finance.
Okay, so you do have some STEM areas that you can get into in the programs at Owen. If you can get into a STEM area, that's really, really good. It gives you up to 3 years of OPT. And also, it gives you more bites at the apple. We're going to talk about the H-1B lottery now. It gives you several bites at the apple for the H-1B lottery, whereas a single year of OPT, if you're not in a STEM area, only gives you 1 bite at the apple. If you don't know whether you're in a STEM area or not, go and talk to Brooke's office, and they'll let you know. It depends on what we call the zip code on your I-20. If your zip code is a STEM zip code, you will be a STEM graduate. If it's not a STEM zip code, then you won't be a STEM graduate. It's really simple. Once you are out of school and on OPT, get a good job with a good company. I would say I use often Dun & Bradstreet, which is a rating service, to find out more detail about companies. If the company's not a household name, you might want to go to Dun & Bradstreet and check it out. If they're a household name, obviously you know what they're like, but you might also want to Google articles and features and things about the company to see if they have, for example, bad hiring histories or bad work environments, if they've ever been sued for things like that before you sign on. Because there are big companies, I won't name them, but we know that several have had management problems. And so you need to be wary of those. Very important. This is really important. When you're interviewing with the company, find out in a general way their policies on sponsorship for the H-1B and for the green card. Really, really important. Some companies only sponsor high-level or experienced employees for H-1B and green cards. They don't sponsor folks right out of school. Some companies make you wait for green card sponsorship for a very long time, up to 4 years. So you got to generally get an idea of what their sponsorship policies are before you accept the job, because you don't want to get in with a company that's going to make you wait 4 years to start your green card application, particularly if you're Chinese or Indian and you're going to be in a long, long wait list. Don't be aggressive. Don't insist on a certain, timing for your sponsorship, that kind of thing. That will get you nixed for the job immediately. But just ask very humble, general questions about their sponsorship policies. Get your work visa. This is usually going to be an H-1B with some small exceptions. Your employer has to include your name in the March registration for H-1Bs every year. Really important, because as I said, we're going to talk about the lottery in great detail in a minute, but it's not a sure thing to get an H-1B. If you're a U.S. MBA grad or a Master's of Finance grad, you have about maybe a 70% chance based on history to get an H-1B. Okay, so it's not a sure thing. You might have to try several times. We've had clients that have tried all 3 years and have not gotten the H-1B, and that's not a good thing. Then finally, once you get on your H-1B or some other work visa, convince the company that you're indispensable, work really hard, be nice to everybody, play good company politics, and they will probably sponsor you for the green card. There are very, very, very few companies in the U.S., big companies, that don't sponsor for the green card. They realize that it is an employee retention issue, employee satisfaction issue, and they kind of have to do it. Okay,
Hey, David.
let's talk. Yes.
We had a question come in. Do you want me to stop you when questions come in on the chat?
No, let's hold them to the end, Brooke, and we'll answer them all at the end.
Sounds good.
So that means
Perfect.
everybody stick around to get their question answered. You can't leave early.
Sounds good.
Okay, so let's focus really tightly on the H-1B visa. The H-1B is the type of work visa that about 95% of you will be seeking after graduation. And this is for folks who are working in specialty occupations. We're going to talk about what a specialty occupation is in just a second. How do you figure out who is sponsoring for the H-1B? Well, there are numerous private websites that will tell you this. Here's one up there, emmyhelp.com, that you can go to. They'll tell you what companies sponsor, where they sponsor, what kind of positions they sponsor for, what the salaries are like, and so on. Okay, so let's talk about that specialty occupation definition. Basically, a specialty occupation is an occupation that requires at least a bachelor's degree in a specific field to enter the occupation. Just a common example would be engineering. In order to be an engineer, mechanical, electrical, civil, you have to have an engineering bachelor's degree. Okay, you can't just run out and be an engineer. You might be a technician without a bachelor's degree, but not an engineer. So that's kind of the general concept of specialty occupation. So when you boil it down, or when you break it down, it becomes what I like to call the three-legged stool. Okay, so first, you possess a particular degree in a particular field. The job requires the same or very similar degree. And by job requiring, I don't mean the employer puts down on paper, hey, this job requires a degree in accounting, or this job requires an MBA. What immigration will look to determine what a job requires are industry standards. What is the industry standard for a business intelligence analyst? Okay, for example, all right? They won't look to exactly what the employer requires. In most cases, they'll look to industry standards. And third, the third leg of the stool, and the stool will fall down if any of these is missing, if any one of the three is missing, the employer is willing to pay the required wage. And by required wage, we'll talk about what that is in a minute. They're also willing to pay the filing and attorney's fees. I got an inquiry just today by email saying, hey, can I pay the filing and attorney's fees myself? The company has never done an H-1B before. And my flat answer is, no, you can't. The law requires the company to pay both with no exceptions and no reimbursement. Okay, so what are the other requirements of the H-1B? Well, you're limited to employment with the employer or employers who petition for you. You can have more than one H-1B at the same time. H-1Bs can be part-time or full-time. Your employment on the H-1B is limited to 6 years with all employers, unless the employer starts a employment-based permanent residence process for you before the end of your 5th year of H-1B, okay? That is filed with the government. Something's filed with the government before the end. It's going to be approved, obviously. It has to be approved before the end of your 5th year of H-1B. Then you get more years beyond the 6 years. Your employment in the H-1B has to be directly related to a degree program that you completed. It doesn't have to be related to your current or your last degree program. It can be related to any prior degree program, even a degree from your home country. So let's say you get an MBA in the US, but you have an undergrad degree in engineering. So an employer could offer you a job in engineering management. No problem. That would probably be primarily based on your undergrad degree in engineering. Not a problem. You can still get an H-1B based on that offer of employment. Now, one question I get a lot is, if I get an offer based on my undergrad degree, we're going to talk about this in a second, does that knock me down or does that knock me out of the master's degree quota? No, absolutely not. The only requirement to get you into the H-1B quota, which is based on the attainment of a U.S. earned master's degree, is the fact that you have the degree. It doesn't matter what the job requires, just that you have the degree. That's all required to get you into the master's quota. And that's extremely important. As I said before, if you're in the master's quota, you have about a 70% chance, more or less, of getting an H-1B. If you're knocked down to the bachelor's quota, that is the quota pertaining to folks with no U.S. earned master's degree, you only have about a 50% chance of getting an H. H's are allowed to have dual intent, unlike the F or J visa. What is dual intent? That's the short-term intent to be a temporary worker and the long-term intent to have a green card. What that means in a practical sense is that you're allowed to pursue the green card process while holding the H-1B and while traveling in and out of the U.S., while renewing your H-1B status, while getting H-1B visas abroad, completely unaffected by your green card application. If an F or a J tried to do that, they would be probably denied a new visa abroad, maybe denied entry to the U.S., so it would be a mess because F's and J's don't have this dual intent. Now there's a possible 60-day grace period between jobs. This is intended to help people who suddenly are laid off, who lose their job without much warning. And as I said before, as I mentioned several times, a limited number of H-1Bs each year, we call this a quota, means there's a lottery each year. And we're going to talk about the lottery several slides ahead in great detail. Okay, what are the employer's obligations in the H-1B process? Well, they have to employ you as they set out in the government paperwork. They can't lie about your wage, your working conditions, what you're actually going to be doing for them, the degree requirement for the job, those kinds of things. If they do, that's a big problem. It could be a problem for both you and them. Their fraud, their lies could be imputed to you. So you don't want that to happen. There has to be a rational relationship between the size and the nature of the business and the job offered. This means that, for example, if a small business offers you a job as a business intelligence analyst, let's say it's a convenience store, and they say, we want to hire this guy as a business intelligence analyst. Well, that makes zero sense to immigration because a convenience store really doesn't need a full-time employee who's a business intelligence analyst. They might occasionally hire someone, as a consultant, as a management consultant in that role, but it would be unheard of for a 4-employee business to offer a full-time job in that area. So that's very important because immigration, there's the so-called laugh factor regarding H-1B petitions. A lot of self-filers, people who prepare their own paperwork and file it, don't realize all these requirements that H's are subject to, and they just file any old thing, as I said, business intelligence analyst for a convenience store. In immigration, when I used to visit the service center in Dallas, way back when in the early 2000s, they would have the laugh board. They'd have a big bulletin board with the most ridiculous cases stuck up on it. And, we weren't supposed to see that, but we did walk by it and checked it out. But, these cases are just ridiculous. Okay. The employer has to agree to employ you only in the geographic areas or area set out in the labor condition application. which is part of the H-1B petitioning process. That is, if they say you're going to be employed in San Antonio, Texas, they can't suddenly move you to San Francisco. They have to amend the H-1B petition in order to do that because it is location specific. And as I said, the employer, as I said before, the employer has to agree to pay the required wage. And what is that? We're going to look at that right now. That's the higher of the actual or prevailing wage. The actual wage is the wage paid to other similarly employed and similarly qualified workers at the same work site. The prevailing wage is a weighted mean or median wages for similar positions in the geographic area of employment. Okay, so it has to be the higher of these two figures. And basically this means that a competitive wage for the occupation of the work site has to be paid. There are 4 levels of wages and separate wage data for higher ed and certain other employers. You can take a look at those wage levels at this URL right here, and be aware that as of July 1st, wages are going to be, the minimum required wages are going to be increased by the Department of Labor. It is possible this will be stopped by litigation, but we don't know yet, so we just have to wait and see. Okay, so let's take a look at, well, just to give you an idea, a graphic of the difference between the prevailing wage and the actual wage. Prevailing wage is big circle, actual wage is small circle. Prevailing wage, let's say, take Dallas, for example. Prevailing wage would be the common wages or the weighted mean or median wage within commuting distance of downtown Dallas, for example. The actual wage would be the wage actually paid at the work site for similarly employed workers in Dallas. So you have to pay the higher of those two figures. All right, so here we have, just to give you an idea of what the flcdatacenter.com wage search looks like. Here we have wages for computer programmers, for example, from San Francisco. And the minimum wage right now, it's going to pop up a little bit as of July 1st, but right now it's $111,946 a year, okay? So computer programming, computer occupations pay pretty well in the San Francisco area. You can find any occupation. The wage level that you're required to be paid is generally going to be wage level 1, okay? But you can find any occupation at flcdatacenter.com. And you have to, it sorts by county and state. So you have to know the county or parish where the employment is going to be located. And then you can figure out, scroll down the list of occupations and click on the occupation you want, and it'll give you the wage levels for that occupation. And it's useful before you accept a job just to check these wage levels, because if the employer is offering you a wage that is well below, let's say they offered you $80,000 for IT work in San Francisco, then you're not going to be able to get an H-1B visa. Okay, it has to be at least level 1. All right, what are the other obligations of the employer? Well, they have to offer to pay the H-1B worker's return to the country of nationality if the person is involuntarily separated before the end of the approved visa petition. And if the employer doesn't do this, they can get in big trouble with Department of Labor. And if they don't do it, you've got a really good bargaining chip with the employer to say, hey, look, you didn't offer to pay my return transportation. I'm going to report you to Department of Labor, and they're going to come down on you with all 4 feet, I can guarantee. They have to notify other workers of the terms of the job by putting up 2 10-day postings or notifying a union if there's a union involved. As I said before, they have to pay attorney's fees, and they have to pay USCIS filing fees. And what are the fees? So the regular filing fee is $460. There's an anti-fraud fee, $500 that everybody has to pay. There's something called the acquia fee that all private employers have to pay, $1,500 if the employer has 26 or more full-time employees, or $750 if the employer has 25 or fewer. There's a filing fee for dependents, $370. There's a premium fee if the employer or you want 15-day processing, $2,500. And then you have attorney's fees. These usually vary somewhere between, maybe $1,000, $1,500 and $10,000. If you're looking for an attorney, if you've been sent by the employer to look for an attorney, I would try to hit a medium fee somewhere in the middle, somewhere between, say $2,000 and $10,000, because you don't want the really high-end attorney. Usually, you don't get any better service by paying $10,000 for an H-1B, and you definitely don't want the very low-end people. You can probably do an H-1B online with some sort of quote-unquote attorney supervision for like $299, I think I saw lately. But don't go there. That's going to be horrible, and you're possibly going to screw this up. Remember that the H-1B is your future. If you succeed in getting an H-1B, you're good to go. You're on a path to a green card if that's what you want. If the H-1B is messed up, then you're not good to go. You may have to do a whole new degree program to be able to get OPT again. It just could be a huge, huge mess and ruin your future. So make sure when you choose an attorney, you choose a qualified attorney that has a lot of experience in doing H-1Bs. Okay. Who pays for what? The employer has to pay for everything. Okay. The only thing they don't have to pay for is the premium fee. If that's for your own personal reasons, say you want to go to a wedding, you need your H-1B approved fast, they don't have to pay for your dependents. But everything else they have to pay for. And there's no ifs, ands, or buts about it. There are no exceptions. They have to pay. That's it. If they don't want to pay, then you need to have them talk to your immigration attorney or talk to an immigration attorney, because obviously, they haven't done many H-1Bs. Big employers that do these all the time, they know they have to pay, and they don't quibble about it. Okay, how does the lottery work? Let's talk about the lottery. So there are several steps to getting into the lottery. First of all, the employer registers with USCIS and names the employees who it would like to include in the lottery. Okay, this year the period for registration is March 9th to the 25th. Okay, very important. If your employer misses that registration period, you will not get into the lottery this year. Then by March 31st, USCIS plans to inform employers which employees have been chosen in the lottery, have won the lottery. Okay. Then beginning April 1st, and the deadline for submission of packets has not been announced yet. But beginning April 1st, the employer is allowed to file a complete H-1B petition packet with USCIS. And I'll tell you what that contains in just a second. And hopefully this is prior to the end of your OPT, and I'll explain why in a couple of slides. Interestingly, if you're not selected initially in the lottery, if they don't have enough submissions by the end of the petition filing date, they can announce more lottery winners. They can hold folks in reserve and announce more lottery winners, which is what they did this last year. So that's really good. Don't lose all hope if you don't get that initial selection. You might get selected if they don't have enough. Now, they didn't have enough this last year because of COVID, and that could be the case again. Employers pulled out of the process because they decided they didn't need as many employees because of COVID, or they couldn't travel, for example. So that's why they had an additional selection. Okay, if you're selected in the H-1B registration process, what has to be filed thereafter? What must the employer file? Well, first they have to file the labor condition application. And this is filed electronically with the Department of Labor. This takes about 7 business days to be approved. So if the employer finds out on March 31st that you were selected for the lottery, they've got to file, usually give about 30 days to file the petition packet. This labor condition application has to be done before they can file the petition packet. So they can't file the petition packet on April 1st. That's impossible unless they've done labor condition applications before, because this takes 7 business days to come back, and it's a prerequisite to filing the entire packet. They have to have an approved LCA. Next, once the LCA is approved, you file it with immigration together with the H-1B petition forms, the I-129H, etc. Evidence of your qualifications, information about the employer, information about the job itself. All this goes to a USCIS service center, okay, a remote service center. Nothing is filed locally. Nobody can rush over to, you know, a physical location and file something. It has to be filed at a service center, and it has to go usually by FedEx. If you're maintaining lawful status in the U.S., which I'm sure all of you are, your status can be changed to H-1B along with your family members, that is your spouse and minor unmarried children. If you've ever been a J in the past, even if you're an F now, you could have serious issues changing to H-1B. You may not be able to change to H-1B. So if you've ever been a J in the past, you need to talk to a qualified immigration attorney about that period of stay and what it means for your future H-1B. Okay, very, 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 very important. And do this as early as possible. If you're outside the U.S. or traveling following your change of status, right after your change of status, you have to get a H-1B visa at a U.S. consulate, just like the process you went through to get your F visa. Unless you're going for 30 days or less to Canada or Mexico. Short trips to Canada or Mexico, you don't have to have a visa to come back, but you need to, Brooke has all the details on what you need to be able to travel in that situation. So it's called automatic extension of visa validity. But otherwise, and the only other exception about not having to have a visa is folks like Nitish over there, Nitish Peters, who's in our session today. Nitish doesn't need a visa because he is Canadian. Canadians don't have a visa requirement. But he will need, to get back in, he will need an H-1B approval notice. And that's one of the great things. I would encourage all of you to become Canadian citizens if you can, because you get lots of nice benefits under U.S. immigration laws. And the best benefit of all is not having to have a visa to enter the U.S. That is the best. Okay. Finally, you get an approval of your H-1B. Usually it can take up to 7 months to process an H-1B or more. If you're antsy-pantsy and you need that approval, you can always pay the premium fee. If it's to keep you on the payroll, the employer has to pay it. If it's for your own personal benefits, such as going to a wedding, as I said before, you can pay it, okay? The employer, just to remind you, the employer has to pay all fees and costs to get you on the payroll or to keep you on the payroll related to your H-1B. Very important to always remember that. Once you're approved in October, you go into H-1B status on October 1st. Okay, that's the beginning of the fiscal year. So until October 1st passes, you will still be in F1 status. You'll be in what we call cap-gap status, and I will explain what that means in a minute. Once you pass October 1st, then you can move, then and only then can you move to a new employer. You can only move to that new employer once that employer files an H-1B petition for you, okay? That petition does not have to be filed within the petition filing period that I mentioned earlier in April. It can be filed at any time, but it can only be filed after October 1st, after you're in H-1B status, okay? And you cannot start work with that new employer until that petition is filed and receipted, until receipt comes back from USCIS for that petition. And beware, you can't really, this is called porting, by the way, moving to a new employer before approval of a new H-1B petition. You can't port if you are, it's very difficult to port, I should say, if you're approved for an employer who is outside the H-1B quota. If you're approved for a for-profit private company, then you're going to be under the quota. You can port at will, no problem. But if you're approved, say, for a university or a nonprofit affiliated with the university, then you can have a lot of difficulty porting, and you really need to talk seriously to a lawyer before you try to do that. Okay, the quota. Let's talk about the quota and why is there a lottery? Well, every year we get about 78,200 visas, H-1B visas. This number is determined by Congress, so it's not subject to change. You know, in Canada, we have a wonderful system where the Ministry of Labor determines how many temporary workers come to the country every year. While in the U.S., we have a screwy system where Congress which, as we all know, is like moving the mountain to Muhammad to get Congress to do anything. Congress determines how many H-1Bs there are. So 78,200, about 58,200 for those with no U.S. earned master's degree, and 20,000 for those with 20,000 extra for those with a U.S. earned master's or higher. Why the funny numbers? You'll hear on the news and reported around that 85,000 H-1Bs are given out each year. Not true. 6,800 is set aside for citizens of Chile and Singapore. And those are slightly different visas called H-1B1s. That's why we have this funny number of 78,200. So it's not 85,000, it's only 78,000. All right. So let's look at quota statistics. This is pretty depressing, but something you need to know. It's been since 2012 since there was no lottery for H-1Bs. 2012, that's the last time. Probably most of you were in high school in 2012 or maybe middle school. So this is a long time. This is sad, very sad, because it means that every year you've got to sit on pins and needles. Your employer has to sit on pins and needles to find out if you've been received in the lottery. And this is really ridiculous. In 2020, about 201,000 petitions were received. We expect probably about that many or maybe even more this year because, as you know, the economy has been picking up a little steam since last year. So we'll see what happens this year. But the bottom line is there's going to be a lottery for H-1B visas every year. So it's really important, one, that you stay on top of your employer's submissions to the government and make sure that those submissions get done timely and properly. And two, if you can get into a STEM area, that helps a lot because that gives you 3 bites at the apple in the lottery. You have 3 years of OPT. If you can't get in a STEM area, don't freak out. I mean, there are lots of people who are not in STEM areas and still get H-1Bs. But if you can fit yourself into a STEM area and you have the ability to carry out a STEM degree program, that's really the best place to be. Okay, who's exempt from the quota? Some of these are very obvious and some are very esoteric, but let's walk through them so you know them all. First, if you've already been counted against the quota within the past 6 years, okay, so you are successful at getting an H-1B approved with a private company, kaboom, it's past October 1st, you're now in H-1B status, you have been counted against the quota, and the fact that you've been counted is now secure, okay? So you can move to a new employer without being counted against the quota again, without going through the lottery system again. This is fantastic. If this is you, if you're looking for a job and you've already been an H-1B in the past 6 years, put it on your resume. Put it in big, fat, black, bold print on your resume because this is an incredibly important thing to let employers know. Very important. Folks who work in higher education are not subject to quota. Folks who work for nonprofit research and government research organizations are not subject to the quota. And notice that I emphasize research there. Most nonprofits are subject to the quota. This is a common urban myth that floats around among folks. They think that United Way and the Cancer Society, Goodwill, those folks are quota exempt. They are absolutely not. They are nonprofits, but they're not nonprofit research organizations, okay? People who work in a nonprofit that has a written affiliation with a higher education organization. The most common example is K-12 school systems. A lot of them have written affiliations with colleges and universities, and so they are exempt from the quota. Folks who work at rather than for a quota-exempt employer, that is on the physical premises of the employer. So let me give you an example involving Vanderbilt. Let's say, the manager of dining services at Vanderbilt, probably that's Sodexo or Aramark, one of those private companies, takes a shine to you. You have an MBA and they want to hire you as manager for all the Vanderbilt facilities, okay? That would be probably an H-1B eligible occupation for an MBA. You'd be working on the premises of Vanderbilt but for a private employer, not for Vanderbilt itself. You would be exempt from the quota because Vanderbilt is exempt from the quota. Okay, very interesting and weird, but yes, that's the rule. And finally, if you're engaged in concurrent quota exempt, quota subject jobs, let's say you're working on the Vanderbilt campus as a grad assistant, you're very ambitious and you want to do your PhD, so you've gone back to school, you're working, well, no, let's say not a grad assistant, but let's say some sort of permanent position on the Vanderbilt campus. Let's say you're a business intelligence analyst, which Vanderbilt has a few of those for Vanderbilt. That's a quota exempt position. They do an H-1B for you, but you're also offered a part-time job off campus with a private company. That would be quota subject. That private company can file for your part-time work on another H-1B petition. Both petitions would be exempt from the quota, as long as you keep working for both employers at the same time. Okay, that's a little difficult to understand, but it's a pretty cool little exemption if you can work it, and some of my clients have worked it in the past. Okay, so I talked a bit about cap-gap OPT earlier. Cap-gap happens when the employer files your H-1B petition packet, the final packet, not the registration information, but the final H-1B packet. If that gets filed before the end of your OPT, so let's say your OPT ends May 15th, your employer files that H-1B packet on May 1st, you will get cap-gap automatically. That cap-gap occurs upon the filing of the H-1B petition, not upon its approval. That cap-gap will extend your F1 status and your OPT through midnight September 30th. Okay. On October 1st, hopefully your H-1B will take effect, and no, there'll be a seamless transition from your F1 status to your H-1B. Now, if your employer files your H-1B petition late, or your OPT ends early, let's say before April 1 of 2021, then you're not going to get all of cap-gap, you're going to get half a loaf cap-gap, I call it. And this is permission to stay in the U.S. as an F1 until October 1st, but no permission to work. So it's really, really important to get that full cap-gap benefit, that you make sure the employer files your petition packet before the end of your OPT. All right, very, very important. You can document your cap-gap by getting an I-20 from your old school where you did your degree program, such as Vanderbilt. It will pop up, usually pops up automatically in your CVIS record when CVIS gets acknowledgement that the H-1B petition has been filed for you, and your school can print out a cap-gap OPT I-20 for you. All right, you can't travel while in cap-gap. That's kind of the bottom line. It's really not a good idea because you don't have a plastic EAD card while you're in cap-gap. All you have is an I-20. And the immigration regulations require you to have that plastic EAD card to travel. So don't plan on traveling during cap-gap. So you probably heard there are a number of presidential proclamations during the Trump period regarding H-1Bs. One of those has survived, only one, while Mr. Biden has revoked the Buy American, Hire American executive order. He has left in place to 3/31 to March 31st the pause on issuance of H-1B visas outside the U.S. The good news is this likely will not affect you at all because it doesn't affect persons in the U.S. who are changing status to H-1B or extending H-1B status. It also doesn't affect H-1B renewals outside the U.S. if it's the same job and the same employer, and it doesn't affect any person in the U.S. as of the date of the order. Probably all of you were in the U.S., or most of you were here on June 24th, 2020 because of COVID travel restrictions. So this pause would not affect probably any of you in our audience today. There are exceptions to the pause to H-1B issuance for healthcare, folks involved in healthcare, folks who are senior management in businesses, and folks who are coming to help drive the economy or economic recovery. But in all likelihood, none of you on this call will need those exceptions. And I would fully expect that the pause will be over on March 31st. Can you get an H-1B through your own business? The short answer is no. It's extremely, extremely difficult. Immigration hates this type of petition. So It might be possible, but very, very, very unlikely. So wouldn't plan on it. What are some H-1B workarounds if you don't get selected in the lottery? Well, one that I like to recommend is enrollment in a new course of study and getting what we call a day one CPT. All of you probably know what CPT is. You've utilized it for internships during your MBA program. One thing you have to be worried about, though, if you're going to do day one CPT, is make sure the program is reputable. The two programs that I recommend to folks are Harrisburg University and Ottawa University. I have personally vetted their CPT programs, and they're very, very good and very well structured. I would not have any hesitation referring you to those two places. Next up is the H3 trainee. This is possible for certain people going into a profession, just going into a profession, which will be most of you graduating with your MBA. You'll be going into a new profession. It's 2 years maximum. The training has to be for a job abroad, not in the US, and training has to be unavailable back home. So if you come from a place like Canada and you're seeking training in, business analytics, you might have a difficult time proving that that's not available in Canada. J1 trainee is sort of similar. It's a lot looser than the H3. You can do more on-the-job training, but it still has some basic requirements that you have to meet. And finally, the L1 transferee. Okay, this is an interesting one. If your employer has international operations, they can transfer you abroad for 1 year, then bring you back on what we call an L transfer visa. This is a very common workaround. Beware, however, the L visa. If you come back on an L visa, you are pretty much locked to that employer. And a lot of employers who bring employees to the U.S. on L refuse to sponsor them for green cards. And they know that you are locked to them. You can't move to a new employer. It's very exploitable. It makes you very exploitable, but that's just the way the L rules work. H alternatives, for citizens of Canada and Mexico, the treaty NAFTA visa is available for occupations listed in the regulations. For MBAs, it can be a little tricky because management consultant is the only neat fit for an MBA in most cases, and that can be very tricky. The TN is given in 3-year increments, and it requires a residence abroad, does not allow dual intent. I mentioned briefly earlier the H-1B1 visa for Chile and Singapore. This is very similar to a normal H-1B, except it's granted in 1-year increments, and it requires a residence abroad, no dual intent. Then you have an E3 visa for Australians, very similar to the H-1B, 2-year increments, no dual intent. And the cool thing about the E3 is that spouses can work. Next up is the J1 professor researcher, specialist, short-term scholar, K-12 teacher, camp counselor, summer work travel participant, and physician. Most of these occupations don't really relate to the private economy except K-12 teachers and physicians. Most of them are for universities, but the J might provide some opportunity for you and should be explored. O1 is a person of extraordinary ability. A lady just inquired today, I can't get an H-1B if I don't get chosen in the quota. Can I get an O1? I said, probably not. You just graduated with your undergrad degree. You're probably not of extraordinary ability yet. So, if you have an advanced degree, if you have a career in your home country that achieves some renown for you, you might be eligible for an O. If not, you're probably not. Next up is the E1, E2. This is an investor visa. If a company that's of your nationality, let's say you're Japanese, and a Japanese company wants to hire you for, automotive-related work in Mississippi, for example, they could do that and put you on an E2 investor visa. E2 investors can either be individual entrepreneurs, companies of a certain nationality, of investor nationality, or they can be essential employees of companies that have the nationality of an investor country. If you want to figure out if your country of nationality allows you to get the investor and trader visa, this is really important. Check out the list that I've got here in red. Obviously, it includes Canadians and Mexicans since they're part of the NAFTA treaty, or what's it called now? The U.S., Mexico, Canada, something, some stupid new name.
Yeah.
Yeah, go ahead.
No, I was just gonna say USMCA. That's what it's called now. Some weird name. Yeah.
USMCA. Okay, great. The L1A and L1B, as I said, this is possible if you're transferred abroad and brought back. It's also possible if you were employed by a company for at least a year abroad before coming to the U.S. and that company wants to employ you again in the U.S. You get a work permit for your spouse too, which is a pretty cool benefit. The problem here is that, again, once you take that L1, you're locked to that company. It's very difficult to move to another company. And sometimes the L1 can work well for entrepreneurs as well. If you have an entity abroad and you establish a U.S. entity, sometimes entrepreneurs can transfer themselves to the U.S. Okay? What if you don't get a job offer in the U.S.? Well, again, as I said, to get a job offer in the U.S., you have to have skills that are in demand in the United States. You have to have a great academic record, okay? You have to be kind of almost better than the average American, your American classmate, because there are certain things the employer has to jump over to get you on board. They have to pay a lot of fees for the H-1B. They might have to try several times for the H-1B, et cetera. So you have to be really good. If you don't have appropriate skills, if your skills just don't fit the job market, you may have to go back to school and retool your skills. Try Canada, Australia, and other countries for immigration. Canada has a really easy process right now. Canada, because of COVID, has not been hitting its established immigration quotas. It's been below its immigration quotas, so they're really anxious to get immigrants right now. So Canada is a super easy place to immigrate to. I would definitely, look at Canada. There's a Canadian lawyer that we use a lot, Ryan Neely. Here's his email address. If you have questions about how to immigrate to Canada, you can hit Ryan up. Also, don't be ashamed if you get a home country, what we call a home country offer. This is an offer to go back to your home country because your language skills or your cultural skills are in demand back there. Lots of multinationals do this. One prominent example is Johnson & Johnson. They hire all the time for home country employment. It's very possible after you work in the home country for a year or two and you have a great record, they may transfer you to somewhere, away from your mom and dad. And that would be a good thing probably in most cases for most people. Although mother's home cooking is always welcome, right? Okay. Permanent residence. Let's see how we're doing on time, Brooke.
We're doing well. We've got more than 20 minutes.
Okay, it's 1:37. Perfect. Okay, so I'm just going to skip very lightly over permanent residence. I'm just going to tell you about the main vectors to permanent residence, and then I'm going to take your questions. How many questions do we have in the chat box, Brooke?
I think we only have one at this point. I believe that's it.
All right. So let me just go briefly over the routes to permanent residence. Some of you, probably a lot of you, are going to go for green cards through employment, and that's great. But there are lots of other ways you can do it too, and we'll talk about those briefly. So first of all, employment-based green cards, great. Your employer sponsors you. They pay for part of the process or sometimes all of the process. Fantastic. Usually they have, if they're a well-established company, they have really good immigration lawyers. They do everything correctly. You don't have to worry about much at all. Kaboom, you're done. Okay. The only problem with employment-based immigration is that Indians and Chinese have to wait a very long time to get their green cards through employment in most cases. So if you're Indian or Chinese, you might think about another route to the green card. And these are the other routes that I'm going to mention today. So first of all, other than employment-based, we have family-based immigration. Who can sponsor you for family-based immigration to the U.S.? Well, first up is a U.S. citizen or permanent resident spouse. This can include, of course, a same-sex spouse these days. Next up is a U.S. citizen or permanent resident parent can sponsor you. Next up is a U.S. citizen child over 21 can sponsor you. So if you have a child born in the U.S., that child doesn't gain the right to sponsor you until the child reaches 21 years of age. And finally, a U.S. citizen brother or sister, that is a sibling, can sponsor you for a green card. Keep in mind that for everybody but spouses of U.S. citizens, parents of U.S. citizens over 21, and the unmarried child of a U.S. citizen under 21, and spouses and unmarried minor children of permanent residents, everybody else is going to have a long wait to immigrate. Brothers and sisters, for example, typically the wait is about 14 years. If you're from the Philippines or Mexico, your wait could be over 20 years to immigrate as a brother or sister. Next up is asylum. This is given to folks in the U.S. that fear persecution upon return to their home country because of race, religion, national origin, social group, or political opinion. Asylum right now was really tightened up under Trump. It's quite difficult to get it. You shouldn't just apply on a whim. You should talk to a qualified immigration attorney that has lots of experience in asylum about your case before you apply, because applying for asylum can have very serious consequences. It can put you out of status, for example, in some instances, and subject you to removal if you're denied asylum. So you definitely don't want to do it lightly. You want to study it very carefully before you do it. Large investment. An investment of a minimum of about $1 million can get you a green card. It can be either in an individual business that you devise yourself and you create yourself or you buy, or it can be in what we call a regional center. You invest as part of a group of investors, and you invest, as I said, about a minimum of $1 million. It's very tricky. This is called the EB-5 program. Again, if you're interested in EB-5, you need to talk to a person who specializes in EB-5. We do not in our firm, but we can refer you to an attorney or attorneys who do, but you really need an EB-5 specialist. It's a very, very difficult area. Next up is domestic abuse. If you've been abused by a partner, a spouse, or a person in the position of a partner and spouse under state law, you might qualify for a green card. If you're the victim of human trafficking or you're the victim of a serious crime committed in the United States, you could qualify for a green card, strangely enough. If you're the beneficiary of a private bill, this is a law sponsored by a congressman or senator for you specifically, then you can get a green card. But let me just tell you that private bills are extremely rare. You know, that congressman that you met at that mixer, that cocktail party in 2019 that you went to, you know, that represents the Nashville area, he or she can't help you in most cases get a green card, okay? Because private bills are reserved for folks in extreme, severe humanitarian situations that are not covered by our immigration laws. They're not intended for MBA students at Vanderbilt. Okay, removal proceedings. If the government finds you working illegally at Papa John's or something like that, they put you in removal proceedings. There are certain instances where the immigration judge can stop the case and give you a green card, but they're pretty rare, pretty rare. And finally, the diversity visa lottery. This is a lottery conducted each year for folks from low immigration countries. I'm going to show you in just a second a slide of those folks who qualified last year. Folks who are born in low immigration countries or folks whose spouse is born in a low immigration country qualify for the visa lottery. I would encourage all of you to apply. Why not? You might win. It's just like any other lottery. Lots of people apply every year, about 15 million people a year. But you know, what the hell? You know, you have 50,000 chances to win, and you might be one of those folks. Vanderbilt has winners every year. So here are the countries of birth where folks were disqualified from playing the lottery last year. And by the way, the lottery usually opens around the 1st of October and closes around the first part of November. This last year, it closed on November 10th. And these were the countries of birth that were ineligible for the lottery, unless the spouse was born elsewhere. Okay? So that's all I'm going to blab today to you. There's a lot more information in the presentation about permanent residence and about myself. But now I'm going to take your questions. So, Brooke, what have we got in the chat room? Let's see.
Yeah. And David, maybe one thing I'll say just before related to that diversity lottery, I received a really nice note from a student who attended, I believe, 2 years ago, had never heard of the PR diversity lottery, applied and got it. So
Wow.
she mentioned that you're pointing that she wouldn't have known of it if you hadn't pointed out. So she was really grateful for that.
Wow. Where was she? What country was she from?
She's from Taiwan.
Oh, wonderful. So that's remarkable because Asians and Latin Americans have the lower chance of winning in the lottery. So it's very remarkable that she won. That's great. That's really great.
She was thrilled. Okay.
Great.
A couple of questions I'll start in on. So first question we had was a question about OPT and H-1B. And the question is, if you apply for the H-1B lottery, you get it, and you're currently on OPT, what happens with your OPT status? Does it go away? Can you hold the OPT STEM extension?
No, it goes away as of October 1st, okay? But that's okay because you're in H-1B status. Now, it is possible to apply if you have lots of years of OPT ahead of you. It is possible, and a lot of law firms are not really super aware of this, or don't do it a lot, I should say. It is possible to apply in a way that allows you to keep your OPT for the full length of your OPT. This is called applying for petition approval with consular notification. But there really is no practical reason to do that. Why? The only effect it would have, it would allow you to save your H-1B, your full 6 years of H-1B for later. But there's really very little logistical or practical reason to do that. But yes, it is possible to keep your OPT, but you have to apply in a very particular way for the H-1B when you file the petition packet. But there really is no great reason to do that. There might be strategic reasons in a few cases. Let's say, I can't think of one off the top of my head, but normally you wouldn't want to do that. So normally what happens is your status is changed to H-1B as of October 1st. Okay, you go directly from OPT with your cap gap extension that I mentioned. You're extended through midnight on September 30th. If your OPT ends before October 1st, if you have a lot of STEM extension ahead of you, then you don't get cap gap. You just stay on your OPT, right, until October 1st. Then your status is changed. You might, if your H-1B is held up with a request for evidence or something like that, that could help you if you have the STEM extension and you have OPT beyond October 1st. That way you wouldn't necessarily have to obsess on getting the H-1B approved by October 1st. You could let immigration do their thing without paying premium processing after October 1st. But that would be a fairly rare situation.
Great, thank you. All right.
Did that answer questions? Hopefully.
I think that did. All right. So I'm going to plunge into a few more questions, and if I get your questions wrong, please feel free to unmute yourself and hop in. So next question is the H-1B quota, is it industry and country specific?
Absolutely not. So it is country neutral. It is industry neutral. Okay. The only thing that the H-1B program currently disfavors, I should say, is working for consulting companies on client sites. It's not a total no-no for an H-1B. I mean, you can do it, but there have to be certain things that are done very, specifically in the petition process to get that H-1B approval. But there's no per country discrimination, no. People ask me all the time, oh, I have a Venezuelan passport and I also have an Italian passport. Will it help me if I use my Italian passport for the H-1B? No, that pretty Italian passport, will not help you. So no, our system theoretically is colorblind and nationality blind. And I say theoretically because the effect of that, as Chinese and Indians know too well, is that for countries with high demand, not for H-1Bs, but for green cards, they end up waiting a long time for their green card because our system allocates the same number of green cards to each country in the world. And that means Tonga gets the same number as India, which makes no sense at all, but that's just the way our system currently works. There's a proposal in the works to change that, but that's been the way it has been since the 1960s, since the mid-60s.
All right, thank you. Next question is, can I travel to Canada or Mexico before October 1st?
Let me see here. No, you can't. You cannot travel outside the U.S. while your H-1B change of status is pending. If you do, you will abandon that change of status. Okay, so your H-1B, but you can travel. Let's say it's May 15th, and your employer paid premium processing. Your H-1B has been approved effective October 1st. In that narrow situation, yes, you can travel to Canada or Mexico for up to 30 days and come back without a valid visa in your passport. But if your H-1B is still pending, if your change of status is still pending, you're going to abandon that change of status and abandon your cap-gap OPT by leaving the U.S. and coming back.
All right, thank you. And I think this is the last one. Oh, let's see. Wait, just got a follow-up to that. Is it safe to travel to Mexico for a week before graduation?
Well, if you're H-1B, that depends. If your employer has already filed the H-1B petition for you, then no, you cannot go, okay, unless the petition has been approved. If the employer has not yet filed the H-1B petition for you, I wouldn't go either because they're going to be filing very quickly. And immigration could deny your change of status because you came back saying, I want to be a student. But actually your intention was to come back and be a temporary worker. So no, I would not go. You don't want to make the Ted Cruz mistake, okay? You don't want to go to Cancun for a week before graduation. Don't do that, okay? Big mistake. Go somewhere else. There are a lot of places in the United States that are just as pleasant as Cancun, okay, or Cabo. Hawaii is really nice this time of year.
And then I think this is the last one I have at present, but I'll check again after this one. So let me see if I can get this right. So question is, can one simultaneously file for H-1B and AOS to green card via approved I-130? And how long does it take to get a green card from family-based PR I-130 approval?
Yes, you can simultaneously do both things if you're very careful and you have good advice from an immigration lawyer. Usually it depends on your location, where you live, to the time limit from filing of the whole packet of the I-130 and the I-485 to get a green card. Generally, I tell people about a year in most cases.
Brooke, I had a question. Once you're done, if that's all right.
Okay. Yeah, I mean, just to follow up to that question, because I was going to ask the question for the I-130, right? You said it takes about a year from the approval of the I-130 through the I-4. I know there's another. I didn't get that.
No, it didn't. No, I'm sorry. You misunderstood me. I meant from the filing. You file everything together. Normally, if it's a spousal petition, either a permanent resident spouse or a U.S. citizen spouse, everything goes to immigration together, the I-130 and the I-485, okay? You get your green card about a year after filing this huge, multi-stage packet. If you're filing, let's say, based on the petition of a sibling that occurred 14 years ago, you're only filing the adjustment of status. That I-130 was approved many, many years ago. What type of filing are you talking about so we can narrow it down?
Okay, yeah, great. So I just got my I-130 approval about 2 weeks ago. but I mean, it's my mom who is a PR here, and I just wanted to really figure out what that process is.
You're going to be sitting in line for about 70 years from the date of filing of the I-130. So don't get too happy.
Okay, great.
Okay.
Yeah.
You need to marry your citizen. You're not already married. Sorry. No, yeah. It's a long wait. As I said in my presentation, it's a long wait for any family preference that's not the spouse or minor unmarried child of a U.S. citizen or permanent resident, or the parent of a U.S. citizen over 21. If you're not one of those things, then you're going to be sitting in line for a long time based on a family petition. You're likely, Chitty, going to get your green card based on employment much, much sooner than through your mom. Okay, so you need to not rest on your mom's laurels. Okay, go ahead and get out there and get your employment-based green card.
Gotcha. Thank you.
Right. Nitish, did you want to ask your question?
Yes, I did. David, I was wondering, I mean, it's a twofold question. One is, how could you use both the TN and like, could you do that? Could you apply for the H-1B and also kind of fall back on the TN visa? And the second part of my question is,
you can do that. Again, it has to be managed very skillfully. You can't hold two immigration statuses at the same time. So what you could do is file the H-1B, try to get into the H-1B registration. If you don't get selected in the H-1B registration, then try for a TN. Okay. So yeah, for sure, you could do both, but the TN would really be a less desirable alternative to the H-1B. TN has no dual intent. It's less complicated as a procedural matter to get it, but for most MBA grads, it's difficult to get because management consultant is the only suitable category. If you're in an area like business analytics or something like that, you might fall more into the IT area, and that might be a little bit easier for a TN, but if you're MBA or Masters of Finance, you're going to be probably a management consultant, and that's a little bit tricky.
cool. And secondly, I mean, this past year, I spend a lot of my time back home in Canada because of COVID. Would that affect I'm applying for OPT right now. I'm not applying. I don't have a full-time job yet. So, but would that generally affect my application for H-1B and OPT? Like, I went back in March as soon as the pandemic hit, and then I was there for Christmas for like 2 months because we were
not at all. As long as your CVIS record remained active during that time, which is not a problem usually, then you're good to go for both.
All right, sounds good. Thank you, David. Thanks so much for your time here.
You're welcome. Anybody else have a question? Nope. Okay, forever now, just ask your question because you got a free immigration lawyer on the line. Completely free. Nope. Okay. Well, thanks everybody for coming today, and thanks Brooke for inviting me. And I look forward to seeing you all in person. If you haven't graduated already, next year. Oh, Chitty has a question, or is that a goodbye, a wave goodbye, Chitty?
I was just clapping. That's all.
Oh, okay. Great. Very good. All right. Well, thanks everyone. And do you have any final remarks, Brooke, or